Let's talk about Social Security. We've talked a lot about the nuts and bolts of how you get a workers' disability compensation case in the workers' comp agency and even in the appellate judicial courts. But let's talk about Social Security disability, because I know you're also processing those claims now and have been doing it even while at Smith Hoy in the last year or two. What's different about a Social Security disability claim in comparison to a workers' disability compensation case?
Well, in some ways they're similar, but there are some important differences. They're similar because you can get disability benefits based on an injury or a disability. Now, for Social Security, it does not have to be a work-related disability. It can be something you've dealt with your whole life, and in any event, just not work-related. It can be mental or physical. Depending on your age and the severity of your condition, you can qualify for Social Security in a number of ways. And one general rule to remember is you can win if you're less than 50 years old, but it's more difficult.
Let's talk too about the mechanics of getting a Social Security disability claim made, and then if it's unsuccessfully made, initially appealed. How's that work?
The first step can really be taken by a Social Security claimant without an attorney, although I still, and you probably have too, have had people consult with you from the very beginning. Some people just feel better knowing that their attorney's helping them along. There's not a lot that the attorney can do except in the background for you. They don't file the initial claim paperwork, whereas in workers' comp, remember, your attorney would file the paper that would get into litigation, although somebody could do that without an attorney too. But anyway, the first step in Social Security disability often is to call or go to your local field office and say you want to apply for Social Security disability. You will get questions to help the Social Security representative determine whether you qualify for what's called Social Security SSDI or SSI. One is based on the work you used to do, and the amount of benefit can be determined by the money you paid into the system. SSI is the other kind, which is you could look at it as a kind of welfare, where it's not based at all on whether you paid into the system. It's just based on whether you have a disability and you meet the means testing. That is, you don't have much liquidity or much assets. They also, the person taking your, you can also do this online. I don't know if I mentioned that. But the basic form is filled out one way or another, where you're giving information about what conditions you have, the doctors you see for it, and the prescriptions you take, what your current functional abilities are. And then the first step for Social Security determination is done by somebody at a desk somewhere. It's a state agency, and they look at all your paperwork. They take a few weeks or a few months to look at the medical records, and this is where the attorney can start helping you again. If you're not sure what to send in, the attorney can help send in records. So the person is looking at your whole Social Security disability claim. They'll have to figure out what standard they apply to you. If you're less than 50 years old, you essentially have to show that you can't do any work. And then the person makes their decision. And I have seen a lot of deserving Social Security claimants who should get those benefits not get them at the first level. That's when you apply for the next level, which is a hearing before a judge.
And again, typically a lawyer advocate is hired by the injured worker claimant to prosecute that appeal.
If they haven't hired a lawyer already, they definitely should hire a lawyer. Again, you can do it yourself, but many times a lawyer is hired for that second level, which is the hearing before the judge. Then the lawyer can really make sure that all the different kinds of evidence are in, and they can help you get through the trial with the judge and help you answer questions.
What kind of evidence does a lawyer gather in a Social Security disability case compared to a workers' disability compensation case?
Well, they're fairly similar. A lot of it is medical, and there's also, besides gathering medical records, because like I said earlier for workers' comp, you know you're hurting, but it's not enough to go into a workers' comp, Social Security or a workers' comp hearing and say, I really hurt, Judge, give me the benefits. The judge is going to say, show me the records. And so usually written records are enough in Social Security. We talked about how in workers' comp, your attorney, it's worth their time and expense to go get the doctor's live testimony and record that at the doctor's office. But that can be done in Social Security, where you go and take a sworn statement of a doctor. But often what's done is to make sure that the attorney makes sure that they have all the written medical evidence, and they make sure the judge sees that. Another important thing the attorney can do is submit some forms that you on your own wouldn't know about, that the doctor wouldn't fill out on their own. Forms that help the doctor address specifically the types of questions that a Social Security judge will want to know.
At the hearing, which is approximately when from the time you file the request for hearing?
Well, depending on where you are in the country, I mean, it's probably going to be at least a few months, and it could be, from the time you first filed your application, it can be a year.
Yes. And then when you file the request for hearing, because your claim's denied by the person at the desk, it's usually about how long right now?
Well, in my experience, and you've been doing it even longer than I have, I'd say 2 to 4 months.
What happens at that hearing?
The judge has reviewed all the medical before, anything in the record the judge knows about. So the judge doesn't necessarily go over every little thing, but often the judge, even if he or she is familiar with your educational background, your work background, they'll ask you to summarize that. And they'll ask you specifically what duties and what functions you had. How much did you have to lift on that assembly job? Because it's all going to go into them determining that ultimate question of, can you do any work? You give your testimony. If you have somebody like a spouse or a friend that wants to help you by telling the judge what they think about your limitations, they often do that by submission of a written, filling out a form. They can testify live as well, but typically the only 2 people that testify live at a Social Security hearing are you and the vocational expert.
What's the vocational expert's role?
Similar to workers' comp usually don't have them live at trial. They have their testimony taken earlier. At Social Security, they're live, and what happens is after the judge has taken all the questions from you and has some idea of what he or she thinks you might be able to do, I'll say he for now, he then gives the vocational expert, after your testimony is done, various hypothetical scenarios. He'll be describing various different kinds of people with different abilities. And you would think that the only pertinent one to describe is you. You know, I just told the judge how limited I am. Why doesn't the judge describe that person? I hear the judge describing somebody that can lift up to 50 pounds and sit and stand 8 hours a day. The judge often starts out with a hypothetical person that can do more than you can, because the judge is not absolutely sure where they're going to come down about thinking what your abilities are. Yes, they've reviewed the medical, they've heard you, but they have the right to go over all the records after trial and make sure they know what they think you can do. And so to be able to have various answers from the vocational expert ready, hoping one of those fits your abilities that the judge ultimately determines, they'll ask about a person who can do a lot, a person who can do a little bit less, a person who can do, and finally by the time the judge describes the last person, you'll start thinking it starts sounding like you. But in response to those descriptions of workers, the vocational expert then is asked to say, can a person of those abilities do any of the past work that Frank did? If it's the same Frank from our earlier examples, the vocational expert will have to say, can Frank do the tool and die? Can Frank deliver newspapers? Can Frank cook? But then, again, similar to the next step in workers' comp, the judge says, is there any other work that you, actual work you can find in the area near the claimant's address that they can do? And if the vocational expert can find any work you can do, that hurts your claim. What you want is you want to have at least one answer from the vocational expert that says, under those circumstances, I can't find any work he can do.
Garrett, does the judge decide the case typically with declaration of how she or he's decided it at the time of the hearing in a Social Security Administration hearing context? You
know, sometimes, whereas we said in workers' comp that basically never happens, in Social Security Disability it can happen.
But they always send a written decision then after that.
Often they don't even tell you how they're inclined to rule. I'd say about 10% of the time, 5 to 10% of the time, they at least tell you at the end of the hearing, right then at the end of the hearing, how they're going to rule. But it's not official until you get their decision, which is often 4 to 6 weeks later. And then the payment arm of Social Security doesn't even know about having to pay you until they get that written decision. And it can be another 2 weeks or more until you get your first money.
And as we discussed in the workers' comp context, there are administrative and judicial appellate opportunities for a worker who doesn't succeed at the administrative law judge level too.
Yes, similar workers' comp, there's another agency level where you can ask the appeals council to, and I think they're changing that name in some districts, but anyway, the appeals council to decide whether the case was wrongly decided. The appeals council might even send it back to the Social Security judge to rehear things. If you're not satisfied with how the appeals council rules, then you can go into federal court.
And again, as you indicated about workers' comp, with each step up the appellate ladder, it gets more difficult for the aggrieved injured worker to prevail.
Yes, and whereas the first level of hearing in Social Security disability, your attorney is quite content to not make you pay an hourly fee, because by law, they would just get a percentage of your back pay, any back pay that's awarded. And if you're not awarded, then your attorney doesn't get paid. Whereas that's the case in how the payment works at the initial hearing level for Social Security. Once you get into the court system, you might have to pay up front.